Hello and welcome to this webinar on understanding employment agreement types, including a specific focus on fixed term and casual employment agreements. As part of Employers Assistance's pre-recorded webinar series, my name is Kent Duffy, lead solicitor and senior employment lawyer here at Employers Assistance. In terms of an overview or an agenda on this webinar's topic areas, we'll be looking at the types of employment agreements in New Zealand, including a specific focus on fixed term and casual employment agreements. Then on to common pitfalls and legal risks associated exclusively with using fixed term and casual employment agreements, or where those sorts of employment agreements go wrong. A couple of case law examples around common problem scenarios at the back end, and then finally some hints and tips on using Employers Assistance's employment agreement builder. Understanding the types of employment agreements in New Zealand. So there are three key categories of employment agreement types in New Zealand. The first is permanent full-time or part-time. There is no statutory definition of either of these. However, generally full-time is considered at least 30 hours or more per week, and equally part-time less than that. The second, fixed term employment agreements. So these are for a fixed period, and you must meet specific legal rules for using these sorts of employment agreements, including having genuine reasons based on reasonable grounds, and also you cannot use these types of employment agreements to test suitability for permanent employment is the key point. The final or third category of employment agreement types relate to casual employment agreements. So that means that a worker who is engaged, or employee rather who's engaged as a casual, there must be no pattern or regularity of work. They are free to decline the work, and how they work is truly ad hoc, is what really it should come down to. It's important practically for employers to monitor these sorts of relationships carefully, as casuals can often evolve into permanent employment agreements, or relationships rather, over time, and default to that permanent sort of relationship. Looking at fixed term employment agreements, there are specific legislative obligations and requirements that need to be met, which are sourced under Section 66 of the Employment Relations Act 2000. In summary, an employer must comply with the various or range of obligations set out under Section 66 in order to have a valid fixed term employment agreement. This includes stating, or the employment agreement stating, how the employment will end, including at the close of a specified date or period, on the occurrence of a specified date, or at the conclusion of a specified project. The other key consideration as per the legislative regime is that employer must have genuine reasons based on reasonable grounds for specifying how employment will end, and advise the employee when and how their employment will end, including the reasons for ending in that particular way. So employers must have good and genuine reasons for using a fixed term employment agreement, and this requires a genuine or legitimate business need. So the employer should always ask itself, when contemplating using these sorts of employment agreements, what is your business need and does it stack up? It's really important for the employer to ensure adequate drafting of the reason or reasons for the fixed term agreement. And again, you cannot use these sorts of employment agreements to circumvent minimum code employment law protections. For example, any particular legal rights or entitlements under the Employment Relations Act 2000 or the Holidays Act 2003. Again, you can't use these sorts of employment agreements to establish the suitability of an employee for permanent employee. The way of doing that would be via only a compliant 90-day trial period clause, and meeting the compliance requirements for using that sort of testing somebody's suitability for permanent employment arrangement. Failure to comply may result in the fixed term agreement being invalidated and the employee being employed on a permanent basis, or claims to that effect, and also arrears for holiday pay non-compliance. So really important for employers to have an understanding of the requirements associated with Section 66, and ensure that when they offer fixed term employment agreements to employees, that the various obligations set out therein are met and have been ticked. Just quickly, some situations where an employer can use a fixed-term employment agreement. So typically they're for parental leave or covering parental leave for permanent employees, or other good reasons like ensuring cover when you have an injured employee who's recovering from a significant injury or perhaps surgery and is required to be off for a lengthy period of time. Other ordinary or common scenarios, or at least accepted scenarios, involve seasonal work, so fruit picking or harvesting, or for peak work periods where, for example, in the retail sector, the busy Christmas holiday period, that an employer or business might need more labour or hands on deck to get through or deal with customer demand. Situations where it's not recommended for an employer to use fixed term employment agreements to test the commercial viability of a role. Gleaming principles from case law that have assessed the issues that have arisen from those sort of scenarios. Generally, the theme is that the employment institutions expect, or in many cases have a view that the employer should rather look at a permanent employment or permanent appointment, and if it is not viable, then consider a formal restructuring process in accordance with usual or normal legal requirements. The other scenarios where it's not advisable to use a fixed term employment agreement is again testing the suitability of an employee. The law makes that clear. It's prohibited, it's unlawful. Or situations where a fixed term agreement is regularly extended or rolled over for no clearly specified reason. That's another common scenario. Casual employment agreements. So the key thing with casual agreements is there is no specific legislative regime regarding these sorts of employment agreements, except in relation to holiday pay obligations under Section 28 of the Holidays Act 2003, and that concerns paying an employee or casual employee 8% holiday pay on a pay-as-you-go basis or as a separate identifiable component of their pay. And basically looking at those provisions and the wording there, along with principles that can be gleaned or established in case law, is really casual employment agreement should only be used where the work is truly casual. So ad hoc, it's legitimately intermittent work, it's irregular work. There is no pattern of work effectively. So a casual employment relationship really should be on an as and when is required basis and include no guaranteed hours or fixed days, no expectation of an employee's availability to work, and that the casual employee really should be free to decline work without issue on that basis that they are genuinely casual. These are the sorts of considerations that employers should keep front of mind when using these sorts of contractual arrangements or contractual employment relationships when taking on employees. Common pitfalls and legal risks with both fixed term and casual employment agreements. So for fixed term employment agreements, not having a good reason to use a fixed term agreement and or inadequate drafting of the reasons. The fixed term period lapsing, and often the employee will claim that they are permanent if they continue working beyond the specified end date, or where there's a defective reason for the fixed term in the first place. Come back to the point around the employer having legitimate and genuine reasons. If those haven't been met, well, then it's open to debate as to the employee electing to basically say this fixed term agreement is invalid because you haven't met the Section 66 legal requirements and I'm a permanent employee. Also terminating in a fixed term employee without a proper process or a documented process. This can lead to successful personal grievance claims and then also claims for payment for the duration of the entire fixed term contract. Casual employment, again, pitfalls and legal risks. Misclassification's a big one or a common one, and that's essentially the scenario where the casual employee simply claims that they are employed on a permanent basis. Holiday pay arrears, so this relates to or scenarios rather, where the employer is incorrectly paid 8% holiday pay, but then being required to reinstate their usual 4 weeks annual leave entitlement and pay that at its full value. Personal grievance claims are the other one. So this happens commonly in the scenario where the casual employee works regularly but is suddenly let go without any process or justification. Usually these sort of scenarios will result in successful personal grievance claims for unjustified dismissal and remedies being awarded. because process is always key. And basically, if the casual employee is not casual, then there is the risk around the argument that they're employed on a permanent basis, and if that is the case, the employer must manage a fair process in accordance with usual or ordinary employment law requirements. A couple of cases around illustrating problem scenarios by way of case law. So in this particular case, there was an employee who worked as a casual housekeeper for a couple of different periods for a couple of different entities. However, the ERA, the Employment Relations Authority, determined that they were a part-time employee and made orders accordingly. The employer challenged this to the employment court and they lost. Essentially, the employment court reviewed the situation and the circumstances that led up to the employee being dismissed and found that no, they were not casual, they were in fact permanent, and this was despite the parties having a written casual agreement. The court stated that it was clear the realities of the employment relationship were those of a permanent part-time relationship or arrangement and not casual employment. So basically, in this case, the employee worked each and every week during the period of employment, and there was a clear expectation of their availability to work. So consequently, they were deemed not to be casual, but rather permanent. And in this case, the court ruled that the employee was unjustifiably dismissed and awarded just over $50,000 by way of various remedies against the employer, including injury to feelings compensation, lost wages, penalties, and interest. The other case that can be highlighted on the slide here, Cross against D-Bound Distributors. In this case, Mr. C worked as a truck driver for just over 1 year, and he was paid 8% holiday pay on a pay-as-you-go basis. He initiated a claim or a dispute based on the application of Section 28 of the Holidays Act 2003. Basically, he said that the exemption for paying 8% holiday pay with his wages or in his usual pay did not apply, and this was because he worked 120 hours a fortnight, 6 days a week on 10 plus hours a day. So there was a clear permanency or pattern or expectation to how he performed his work. It was not intermittent. It was not irregular work. In summary, it was not casual work. In fact, he was employed on quite the opposite basis, basically a full-time basis. And in this case, the ERA determined that he was entitled to 4 weeks annual leave payable in the usual way, which amounted to just over $8,000 plus interest. The key takeaway from this particular case is that the ERA member made it very clear, as per the last bullet point on the slide, that an employer who does not comply with the conditions associated with the exemptions under Section 28 of the Holidays Act does so at its own costly peril. And what that basically means is to employers, the takeaway there is that you can only pay 8% holiday pay on a pay-as-you-go basis in two scenarios. Scenario one, where the employee is working under a casual employment agreement and how they work is genuinely casual, and two, a fixed term agreement or a legitimate fixed term agreement of less than 12 months. Those are the only scenarios where Section 28 of the Holidays Act permits payment on a pay-as-you-go basis for holiday pay. Employers Assistance has a comprehensive employment agreement builder on the employer's toolbox where members can generate and customize standard form template employment agreements to suit their requirements. There are options for full-time, part-time, fixed-term and casual employment agreements there that can be created. And there is also help commentary and various guidance notes to aid compliance along with phone support via the employer support package membership subscription available to members. That concludes this webinar on understanding employment agreement types with the specific focus on casual and fixed term employment. I hope you've gained some useful information, insights or takeaways out of this webinar, and if you require any further support then feel free to reach out www.employers.co.nz or 0800 15 8000. That's 0800 15 8000. For non-members, feel free to check out our website and the various membership options for joining us and accessing our services, including our range of templates and the Employers Toolbox online.